Right, ladies and gentlemen, I'm going to start on this presentation. So thank you very much, everybody, for joining on this. I've muted everybody, with the exception of myself and Richard, who I'm going to ask to introduce himself in a couple of minutes. These can be a little bit tricky, so I hope you'll stick with us on this. I know this is something that I'm not particularly brilliant at, having only done it once before. But the idea and the general objective of today is to kind of expand on a subject that I am very interested in and have been for some time, and that is the subject of dilapidations. I know it affects so many people. Simplistically, we all know, all of us who are tenants out there know that the whole idea of dilapidations is really something that well, the whole idea of running a pub is you take on a pub and you give the pub company deposits, and you give them a lot of money with fixtures and fittings, and then you run the pub for 5 years or 10 years and you make loads of money, and you then retire at the end of it to the Bahamas or whatever it is that you do. But the reality of the situation is that you run your pub for 5 years after giving the pub company loads of money, and at the end of those 5 years or 10 years or however long it be, if you manage to last that long, is that they will use dilapidations to extract that money that you've given them at the start. And it's always amusing to me that those dilapidation bills somehow seem to arrive at exactly the same sort of figure that you've given them back when you started out on your pub journey. It's a subject that I profess to have invested a lot of time investigating, but I am not an expert. Far from it. I am not a surveyor, and wouldn't ever pretend to be. And whilst I've had some success in some battles with regards to dilapidations, I was always very, very keen to understand and speak to somebody with a lot more expertise than I have. Hence asking Richard to come along. We've had some questions posed already, which I've put to Richard, which we'll kind of, if it's okay, what I will do is read them, or simplify them perhaps and read them, and then get Richard to respond to those. They may answer a lot of people's questions that they have already on this meeting. There are a couple more that Richard isn't aware of, which have dropped in my lap, which I'm going to surprise him with and see if we can quickly get through, if they've not been any covered. And then if there's anybody else then that wants to throw some questions that have not been answered our way, if we've got time, then we kind of allow that, if that's all right. So if you can, as I say, if you've got any, we'll make it clear right at the end that we've run out of questions, and before we throw it open. And if you can use the little button somewhere at the bottom, which the chat button, to put up a question. If we've got time, we will. We're recording this, so we will put it out for people to see. So there's no need to take notes or anything like that. And at that point, I think rather than just waffle on, I shall pass over to Richard to introduce himself and to crack on from there. Is that okay, Richard? Over to you.
That's great. Thank you very much, Dave. I am Richard Kay. I'm senior partner of Beckett and Kay. We're a firm of chartered surveyors in London. And probably the most important thing you need to know is that I have no idea how to value pubs. But hopefully that's not necessary for the purpose of this exercise. It's a slight fib to say I have no idea how to value pubs. It's just that it's not something that we specialize in, so I wouldn't pretend to be able to do that at a drop of a hat. But what my firm does specialize in is this an area of dilapidations to do with whether or not a landlord has actually suffered any loss. And that's a valuation exercise that can be undertaken at the end of the lease. So I think that's why Dave has got me involved, because there are, whilst the starting point for a dilapidations claim is for a building surveyor to inspect a property. Obviously, if the landlord sends their building surveyor in and inspects the property and produces a schedule of dilapidations, which in theory should identify any breaches of covenants within the lease. So there could be repairing covenants or other covenants such as decorations and the like. And then the tenant has an opportunity to respond, and the tenant would first of all instruct their own building surveyor to have a look at a schedule. So my firm doesn't get involved in that part of the exercise, the initial part, but there are protections for tenants from being subjected to unfair dilapidations claims, and that's where we come in, because there's both statute and common law, which combined essentially say that a landlord can't claim more than they've actually lost. And the test for that loss in the context of dilapidations is whether or not there's been a diminution or a loss in the value of the landlord's interest. So that's what my firm does. In terms of pubs and dilapidations, I have actually been involved in one dilapidations claim where the landlord was the outfit who shared their name with some puppets, and the tenant, who was my client, was the outfit who refresh parts that others can't. And that was a claim on a fairly large pub and a fairly large claim, but the landlord was after 1.3 million in the dilaps claim, and it eventually settled for 635,000. So there are savings to be made on all scales.
Okay. I mean, that's a very unusual sort of level of figure that we're probably not used to, and I think it's worth just pointing out to everybody on here that the sort of level that normal dilapidation claims, I think Richard will correct me if I'm wrong, are normally involving commercial properties. They're normally involving very large sums of money, millions of pounds quite often. And the figures that we're talking about are, whilst no less important to us as individuals, you know, substantial sums of money, are more in the tens of thousands rather than hundreds of thousands. Although we have experienced a dilapidations claim of nearly 200,000 on one occasion, which is how we met, actually, through a colleague who then did a survey which came in at 22,000. Pub, which is
the point is the principles are the same. The protection for the tenant is the same regardless of the size of the claim. So
that's really what we're very interested in. It's what, I suppose, the answer, the key question I think a lot of people are on here, of which we've got now, that's nearly 45 people, which is fantastic, is what can the tenant do to protect themselves at the start and at the end of a dilapidations, the dilapidations process, and what can the pub company do legitimately, and what can we do to protect ourselves? So okay, so thank you for that. With kind of no further ado, I'm going to go through these initial questions, if that's okay with you, Richard.
Of course, yeah, no problem.
And I'll go through the ones that obviously I've prepped you with, and the very first one, I'm not going to necessarily say who these are from, because I basically cut their name off and I can't find it in my original document, but I will. And the first one was quite a lengthy one, but it, and I do know exactly who this has come from. This is from a pub that I've been dealing through, which was an MRO claim, Marston's pub, the Queen's Arms in Bakewell. And simplistically, the story behind this, which was quite a lengthy one, was Gary and Linda took on a pub back in 2005, and in this instance they knew that the pub had a serious problem with the wall. So the wall had a big bulge in it. It was a listed building. It was a very serious issue. They were aware of it, but they were put in a position whereby they still took the pub on, because the alternative was to walk away from the pub and lose a vast sum of money. And over the 15 years that they were in the pub, that wall never got any worse, and no work was done to it by either the landlord or the tenant. And despite having discussions over it, no agreement was put in place as to who was actually going to do any repairs to that wall. And in fact, until they chose to go through the MRO process, which I think I might have explained to you, Richard, for your benefit, is when you trigger the legislation that enables you to go free of tie, they were then instructed to repair that wall to the tune of 70 grand. So I suppose that the question is, from their perspective, having taken on a pub on a full repairing lease, being aware that there was a pre-existing problem, do they have any protection based on the fact that there was no attempt by the landlord or themselves to do the work over the preceding 15 years?
I should caveat everything I say, which is with the suggestion that in serious issues you really should speak to a lawyer rather than me. But because this is ultimately, it's a contractual issue. The lease, normally we say to trainees when thinking about surveyors and learning about leases, that you treat the lease as the Bible, and if the lease tells you to stand on your head every Wednesday afternoon, then you need to stand on your head every Wednesday afternoon. But there are obviously a number of grey areas with something like this. I think the normal principle is one of sort of fact and degree, is the expression that the lawyers like to use. So it may be. Sorry,
families who say they had doors shut in their face, they had to really shout to be heard, and they believe that this funding will hopefully prevent future deaths, prevent families in the future suffering the kind of loss that they now have to live with.
If you mute everybody and then ask Richard to unmute
again, yeah.
Right. Are we all? Right, Richard, can you unmute yourself now?
I haven't actually been muted yet.
I was unable to.
I think the noise has stopped. So
go on then.
Sorry about that. Yes, the lawyers with this sort of thing would refer to fact and degree. So was it, whilst this was a problem that was known at the start, is it something that is actually beyond all comprehension, that the tenant taking the lease and the landlord granting the lease could realistically expect the tenant to be liable for? Obviously, an extreme of that is if the whole property needed rebuilding, for example, or something like that. There used to be this concept of inherent defects, although I think that's rather faded with more recent case law. But if we envisage, presumably this is a period building, it's been tied back at some point in the past, and probably if it's left for another 50 years, it'll still be there, but albeit with a bulge in the wall. And the question will be, well, first of all, from a dilapidations point of view, has there been any disrepair? Has it changed from one state to another? And the building surveyors will be able to answer that question. And it might be considered that whilst obviously it's not a straight, perfect wall, it's nonetheless functioning as a wall, and it's an old property, and it'll probably continue functioning as a wall for many years to come. So that might be a different scenario to one where, because of neglect, it's about to collapse or something like that. So it's a tricky one. There is some case, there's actually a case which I looked up called Lister v Lane, going back to 1893, which was to do with the age and general condition at the time the premises were taken. And so if your tenure there is only a very short period of time over the lifetime of the building itself, it might be considered that some extreme repair that's required, which is almost total reconstruction, goes beyond what could be reasonably expected of a tenant. So it's very much a legal point, but I think there's certainly some defense arguments there. From a diminution point of view, a valuation cap on a dilapidations claim, the question is whether or not that problem, the bowing of the wall, is going to affect the running of the pub at all, and the generating income. So if at the date that the valuation takes place, and the idea is that the valuation takes place at the lease expiry date. We had two identical buildings, one with a perfectly straight wall and one with a bowing wall, albeit tied and secure and not about to collapse. Is there going to be any difference in the value between those two in terms of the ability of the pub to generate profits? And the answer there may be, well, no. So some customers might prefer the quaint, ancient bowing wall to go and visit. But so I'm afraid it's not a black and white yes and no. But I think there definitely might be some defences to a claim that you would have to rebuild the entire wall.
Right. Okay. So, is there a specialist? A lawyer, solicitor, a branch of legal support for that sort of specialist argument?
Absolutely, there are property lawyers who specialise in dilapidations, and they come in all shapes and sizes as well. You know, there are regional lawyers who no doubt charge reasonable fees, and there are city lawyers in the big firms who charge very unreasonable fees. But there are plenty of lawyers who know about dilapidations. The go-to book for lawyers and surveyors on dilapidations is this one, Dowding and Reynolds, which is compiled by two barristers. And most solicitors worth their salt will have access to that and can look up all sorts of queries and case law and how do you do this and that, and what's the situation, what's the fact and degree test all about, and that sort of thing. So yes, it's absolutely a specialist area where solicitors should be able to give good advice in your favour.
Brilliant. Okay, so Richard, thank you for that. The second question we put in front of you was, if you improve a property following occupation and signing a lease, e.g. repair and redecorate, for example, sash windows, what generally are the dilapidation obligations following these improvements?
Again, each lease you'd have to look at the terms very carefully, but the an obligation or a covenant to repair is actually recognised as meaning to put into repair. Clauses often do go further and are very explicit in saying to put and keep in repair. But even if it just says repair X, that normally means if it's in disrepair, you have to put it into repair. So the fact that if you have a full repairing lease and you have, well, the word improvements can cover a whole range of different things, obviously, from using a posher type of wallpaper or actually making a physical improvement to the building, like rewiring or something, but or extending the building with landlord's consent. But I don't think the fact that you've actually complied with an obligation or maybe gone a bit beyond an obligation really changes that obligation at the end of the lease. You will have to leave it in repair.
Right, okay. That kind of, I'll duck out of one question there and I'll just go to the next one. Could you explain simplistically what a put and keep agreement is?
Yes, it's basically if something's in disrepair, you immediately take on the responsibility to put it into repair. Now, some clauses can, some are sort of explicit. You can find some examples with put and keep clauses where they actually include an obligation to do certain works within a certain time frame from the start of the lease. And I think it's the idea is that if a time frame isn't specified, then you substitute that for within a reasonable time, and then you can have all sorts of arguments about, well, what is a reasonable time? And this is obviously why, as Dave was suggesting, one of the most important thing when you're taking on a lease is to take advice as to what it is that you're signing up to. That doesn't mean that the defence, your diminution defence, isn't still there. So you could take on a put and keep clause, if the landlord doesn't take steps to enforce it at all, and you get to the end of the lease and you still haven't done it, you are still protected by the statutory and common law cap that the landlord can't claim any more than he's lost. So if it hasn't actually made any, it doesn't actually make any difference to the landlord that you didn't put that item of disrepair into repair, then the landlord doesn't have a claim. So that doesn't alter that. But I think generally speaking, unless you've got a very clear schedule of condition, which is well referenced within the lease, limiting your obligations, wherever you sign a clause saying that you're taking on the obligation to repair, or more so even to put and keep in repair, that's kind of what it means you have to do.
So the next question was relating to the diminution of the capital value, which was one of my questions that I actually wanted to clarify. But so my understanding is that the loss, the maximum loss that the landlord can claim is the diminution of the capital value, the reduction in the capital value. In a pub, because pubs are valued in such a slightly different way, because quite often pubs are valued as part of including the business within them. Do you envisage that being having an impact on that defence?
Well, I think I obviously have been thinking about this, and I don't see that it excludes the defence, because if you're valuing something on a profits method, which is essentially the method used for pub valuations, and you are envisaging, which is what you do when you're trying to value something, you're envisaging that it is changing hands, it is being sold. Your hypothetical purchaser is taking into account everything about the business. So obviously, if they're thinking that it's an ongoing, it's traded at a particular level of profits and they anticipate that's going to continue, that's one thing. But if they were given the choice between two identical pubs trading identically, and one has a big hole in the roof and the other doesn't, they are likely to discount their bid for the one with the big hole in the roof, because in order for those trading profits to carry on at the same level, you're going to have to deal with it. So likewise, there may be so that's in the landlord's favour, that they will say, well, I have suffered a loss because the repair that needs doing is fundamental to the running of the business. Obviously, the flip side relates to any repairs that actually don't have any impact on the ability of the pub to trade or to generate profits at the same level. So there may well be items in a dilap schedule that fall in that category, so that it would be very difficult for a landlord to prove that there has been any loss arising on particular items not having been undertaken.
Richard, how much would a typical Regulation 18 survey cost at an average sized pub, do you think?
It's a tricky one for me to answer because of the sort of nature of work we do. We tend to be involved in the higher value stuff with silly fees because the numbers are also so much bigger. But I would have thought a local valuer in any particular area would be able to give a view on diminution for, I don't know, a few £1,000s, maybe a bit less. But there are other ways of getting to a similar answer without needing to instruct a valuer, because most building surveyors should understand this principle, this diminution principle. And so there are one of the most helpful things in sort of smaller value claims is to undertake what we would refer to as a shortcut diminution valuation, which arguably doesn't actually involve valuation at all. What it involves is the building surveyor, maybe with some help from a valuer in terms of understanding what might or might not impact on trading ability, to go through the schedule of dilapidations and knock out those items which it's very difficult to see would have any impact. and therefore you are reducing the full dilapidation schedule only to those items which are obvious to anybody, need to be undertaken in order for the business to keep running at the same level. So that's on the one hand, that's a shortcut diminution which most building surveyors can do with a bit of hand holding, and you'd need a building surveyor involved in most cases anyway, because first of all, you need to make sure before you even get to valuation that the items being claimed by the landlord are genuinely your responsibility. So is the defect that they've identified actually a breach of your obligations, or is it something else that maybe the landlord is responsible for? So a building surveyor would be involved in doing that, and then it's sort of an easy next step for them to say, well, actually, this is never going to be undertaken because it's not going to have any effect on the running of this business, and knock things out of the schedule that way. So that is a very sort of useful tool to use. We do often get involved just on a desktop basis with lower value claims, and that often hand holding the building surveyor in sort of guiding them on how to do that. So that can be relatively inexpensive. But there's one other main issue which affects a landlord's ability to claim, and that's the concept of supersession. I don't know, Dave, whether you want me to get onto that now. This is sort of related to the prospects that any purchaser of the pub at the end of the lease or new tenant would actually do some sort of wholesale refurbishment of the premises, which might the word supersede works which appear in the schedule of dilapidations that you might have been otherwise liable for. So for example, if there was a partition wall somewhere within the pub which you were responsible for leaving in good decorative repair and good repair, general repair, and the most likely new tenant or new purchaser of the building is going to knock that wall down to create a larger open plan area or something like that, then the landlord can't possibly have lost anything in terms of the value of the building by the fact that that wall hasn't been decorated. So that is the concept of supersession, and there may be a number of items in that category, most obviously internal items, in a situation where some major form of refurbishment or modernization is most likely to happen once the lease has come to an end.
I think that's, so everybody will be very interested in that particular point, because a lot of the moment a lot of pubs are being taken back at the end of their leases for managed operations. So therefore, if the pub company is taking back a lease from somebody and going to manage it themselves, then theoretically they are going to quite often brand it up themselves and do lots of things to it. So therefore, arguably, a lot of that work comes into that category of supersession, I would say.
Absolutely, yeah, indeed. And again, a good building surveyor should be able to assist with that part of the assessment. It's a bit like looking at things which would have no impact on the business if it was continuing as it was, but going one step further, saying actually there's no impact on the claim because this item will no longer survive when this lease comes to an end, because the space is being knocked about so much that it will no longer exist. That's obviously a harder argument to run with external items, because it's unless we're into the redevelopment category where there can be no claim, obviously, if the building is going to be knocked down. Most buildings do need to be wind and watertight. So if the roof needs repairing, regardless of what's going to happen internally, that is likely to survive.
Do you know of any case law that specifically relates to dilapidations in pubs?
No, I thought I'd found one because the name of the party was Brew Brothers Limited versus Snacks, and I thought, well, that must be a pub. But actually it was a service station in 1970, but it has some interesting things to say about dilapidations, which might be helpful in pub scenarios. But obviously, dilapidations claims do happen in pubs. I've mentioned the one that I was involved in a couple of years ago, but I'm not aware of any that have actually made it to court, and or at least made any significant impact in terms of case law. That's not to say that there might not be one out there, but I haven't found it.
Well, it's encouraging, because, you know, my belief is very much that a lot of the arguments that are put in front of us for dilapidations are, for want of a better word, you know, the pub company trying it on, knowing full well that the tenant doesn't have potentially the financial means to challenge it, which is you know, which is why I think there isn't a lot of case law out there. So that is, personally, I find that encouraging. One of I think the last question that we kind of put in front of you is there a low-cost dispute resolution mechanism for arguing dilapidation claims, i.e. through the Royal Institute of Chartered Surveyors?
Well, there is indeed. I don't know if you can see it. There you go. There is the Royal Institution of Chartered Surveyors Dilapidations Dispute Resolution Scheme.
Fantastic.
So it's a reference to have an independent expert appointed by the RICS, and the advantage of that, of it being an independent expert, is that it, in theory, it levels up the both sides' arguments, because an independent expert, basically, whilst they will take on board any submissions made to them, they are entitled to come to their own independent decision. Whereas with an arbitration, both sides put their case, and the arbitrator has to make a judgment based on the arguments put before them, rather than going off on a frolic of their own. So having an independent expert scheme is helpful to the little guy, as it were.
Presumably that there is that's an element of cost to that.
Indeed, yes. I'm not actually sure what there must be sort of an application fee or something that's payable, and I'm afraid I don't know the answer to that. The only other limitation to the RACS's scheme is that in theory you can't apply to it until 9 months after the expiry date. So if the dispute is still going on, that's when you can make that application. In theory, there's nothing to stop the parties agreeing between themselves to have an independent expert or an arbitrator appointed. A number of building surveyors act as single joint experts in dilapidations claims. The difficulty will be whether you can persuade a landlord to give up control of the process by trying to get them to agree to do that.
Okay. There's a number of questions that have come up on the screen. I don't know if you can see those, but there was one that was sent through to me yesterday morning, which kind of I'll try and very briefly explain. So we turned part of our pub into a music venue, removed one of the bars for the stage. We left a small part of the bar beside the stage intact. However, it's part of the bar which had a bar flap, and our surveyor is requesting we put the bar flap back on, even though the bar no longer exists. So that's kind of a slightly confusing one, but nevertheless a common sort of problem whereby something has been removed, the actual purpose of that no longer exists, and it's been instructed to put it back in place. Presumably,
this is at the end of a lease, is it?
The end of it, yes.
Well, the test there will be whether the landlord actually spends the money putting it back in place themselves once the building is handed back. Obviously, if it was a landlord's fixture and there was no consent to remove it, or if consent was given, there was a reinstatement obligation, then and the landlord, importantly, and the landlord actually does that work when the lease expires, then it's likely to be a valid claim. But actually, if the space has been altered and is going to remain in that altered state going forward, then obviously there is no loss, because the landlord won't incur the cost of putting it back.
So quite often the problem we have here, Richard, is the fact that many of the tenants that are coming out of pubs have money that they are waiting to be returned to them. And that is almost quite often held at ransom against some of this work being done. Is there a way around that? Because, you know, is there something you would suggest that we could tackle that, or is that more a legal aspect of the?
I think that would be a legal aspect, unfortunately. Obviously, as often happens in sort of smaller value claims, the difficulty is, and unfortunately this is where larger landlords know there is a difficulty, that it's very costly for the tenants to put up the strong fight, or it can be costly to put up a strong fight on that sort of thing. So, but in Scotland, it's a slightly different state of affairs. I don't know whether you have any Scottish pubs, but it's because they have these things called payment clauses, and it is established that they don't have the protection of the Landlord and Tenant Act 1927, and where there's a payment clause in the lease in Scotland that says something along the lines of, at the end of the lease you will pay the landlord the cost of identified by the schedule of dilapidations, it's tough. You have to pay the landlord the cost of the schedule of dilapidations regardless of whether or not that work is ever done. But that's not the case in England and Wales. So a deposit of that nature should be protected by the same question of, has the landlord lost anything?
Right. Two more questions, and then if we go on to the ones that are put up on the screen, if we can. A gas heating system was taken out. It was very old. It was replaced, and the boiler was replaced, and some of the radiators were replaced. However, the pub company is asking to replace the missing radiators at the cost to the tenant, even though there is no longer a boiler, a functioning boiler. Is that a similar sort of argument?
Indeed, yeah. I mean, if what they're proposing is to put something back which has been replaced by something different, which is perfectly functioning and is not going to actually be replaced, then they've not really got a leg to stand on.
Right. So a lot of these issues really are very strong arguments, but we've just got to find potentially the financial means to fund those arguments. This one is probably a little bit slightly different. It relates to the finish that's required. So the individual has done some work to the pub. They've taken up a carpet, they've put down a floor. The flooring was particularly designed to fit in with the style of the pub that they were running. It's their choice of decoration and it fits in. What I do remember myself having come across this. There is some case law on this, I'm sure you will confirm. How does the law stand with regards to the finish of the requirement from the landlord?
Often repairing covenants will specify that where it's the final sort of round of decorations or fitting, that it's at the landlord's subject to the landlord's approval as to colours and the like. Carpets, obviously, it depends, because you can have both scenarios. They can either be treated as landlord's fixtures, in other words, that the landlord gave the tenant the carpet at the beginning of the lease, and therefore the tenant has to give the landlord back a carpet at the end of it, or it might be a tenant's fixture, in which case the only obligation would be to remove it at the end of the tenancy. But I think a landlord might have a fairly valid argument. I mean, if we took the extreme and that the carpet was branded with some extreme name of a pub, which was, it was then not going to have that name going forward, obviously the landlord would have to replace it, and there could well be a claim. Okay.
So we've got 20 minutes left, and I want to have 5 minutes to kind of say thank you and to just basically pass on my thanks to you. So quickly, are you able to see those questions yourself? Because I am not.
Fantastic. Are these in the chat box?
They are in the chat box, yes.
Okay.
So you might, the individuals who have posted those might just want to expand on them if necessary. So I do a lot of pub changeovers after a new surveyor for dilapidations has come from another brewery, and they produce a delapse list, half of which turns out that the tenant is not responsible for, but by then, too late, as the tenant has already paid for the delapse. I mean, a normal story, to be fair. The situation we see all the time, one of the biggest complaints I have from people is that they are given a schedule of dilapidations. They have very little time to get them completed. They eventually kind of walk out the pub and leave the landlord with half of their deposit as compensation towards those dilapidations. And those dilapidations are never repaired because they then see a new tenant come in and the work is never done. I suppose the question there, or I'd like to pose is, do you have the ability to go back into an argument if you have had dilapidations levied against you in the sum of 10 grand and that work has never been done and you can prove it's never been done? Do you have that argument? Can you use that argument then?
It's a very difficult one. If the landlord had made some express statement, which could then be proved to have been a barefaced lie or fraud in saying, I am going to spend £5,000 fixing this next week, please pay me £5,000, and actually they never intended on spending the £5,000 and they've misrepresented what they're doing, then I'm sure there will be a legal recourse to recover that. But it's always a tricky one. There's this concept that the landlord can have a genuine change of mind, and trying to prove whether it has been a genuine change of mind or it was a barefaced lie is, I'm afraid, a very difficult one, and likely to be costly in terms of the legal efforts at recovering it. Obviously, if there are very large sums of money involved, that might well be worth pursuing.
I think it's worth something for us to explore because, Richard, I can assure you, I've been doing this now for 12 years. I've been helping tenants on dilapidations issues for that length of time. And I know of no occasion, with the exception of probably compliance, in which a landlord has charged a tenant for dilapidations and then done the work. I just don't know. I can't think of any time where I believe it's happened. So Liz, having taken over 2.5 years ago, our gas certificate was up to date and we took the lease on from Enterprise Inns. Nothing with gas has changed, yet we're now being told that the gas meter is too small. It's a domestic, not commercial. With a fully repairing lease, where do we stand?
I fear that you've probably got statutory compliance clauses in the lease as well, but that's probably within the put and keep type category.
Okay. Damp issue, could this right, so they've inherited a damp issue there. If the damp is already pre-existing and it's structural, is there an argument there that they could use?
Again, I'm afraid it's this fact and degree test, which is a bit woolly. I don't think there'd be any obligation to improve the property, for example, by putting in some sort of damp proof course, because you'd then be giving the landlord back something different to what was given to you. But obviously for your own functioning purposes, you probably need to do the work. So it's always a tricky one, that.
If somebody's taken on a 5-year tenancy, full repairing, men's toilets needed work doing to them, the work's not been done. Again, would that come down to an argument at the end of it? The expectation is that they're potentially going to be asked to do some work to them. Would that come down to the argument of diminution?
Well, not if the first question is, has there been a breach of the covenant? And if the covenant was to keep them in repair, then they have to be in repair. Obviously, if even the test then is, even if you were to put them in repair, are they of such a nature that the landlord is going to renew them with something completely different anyway? Then your diminution defence comes in. So if they're very old, 1970s looking toilets or something that any modern pub owner would come along and strip out and put something much posher in, then the fact that they've been left in disrepair is not going to cause any loss.
Right, okay. Nigel, Regional Director of Camera. Thanks for coming on board, Nigel. How does a delay to rebranding affect supersession? So take a pub back for its own use, but not plan any works until a further period of managed trading. Is that acceptable or not? Does the work, what I suppose the question there is, what period of time does the work have to be done within?
Well, I'm not sure there is a hard and fast rule about the period of time. There is a well-known dilapidations case called Shortlands, which was to do with an office building. But in that case, an event happened a year after lease expiry, which was deemed to have an impact in the tenant's favour, actually, in that case, on the claim. But the test again would be if the operator who was coming in and running the pub for a bit before doing their own refurbishment has to undertake any of the repairs in that interim period, then it's likely that there will be a loss identified compared to them taking the pub in fully repaired condition and running it for a few years before rebranding. So the incoming tenant would likely argue that they shouldn't pay as much rent because they're going to be faced with some immediate costs.
Okay. Is there an obligation to a landlord to provide a schedule of delapse at the beginning of an agreement, or a schedule of condition?
No, as far as I'm aware, unless there's anything in, I don't know anything about the pub code, for example, but I don't know whether that touches on anything like this. But certainly in a commercial landlord and tenant world, there's no obligation on either party to have a schedule of condition at the start of a tenancy.
So if the schedule, and the next question really is, if the schedule of condition does not include, does not reference something, but the dilapidations does reference something at the end, is there an argument in the schedule of condition? The schedule of condition was incorrect, firstly, and it's tough, basically.
Schedules of condition, I'm afraid, can be a nightmare for both parties because they're very rarely fully accurate. They're either very tertiary or they're so detailed that they're ridiculous. The fact that something was missed on a schedule of condition at the start, which is then identified at the end, I suppose the landlord would say, well, you Mr. Tenant, had the opportunity to look at the schedule of condition at the start and you didn't see it either. So it's tough. I think that's probably what the landlord's argument would be. You're then back, it depends what it is. I mean, if it was some form of defect which no reasonable survey at the beginning of the tenancy would ever have been able to identify, then the tenant might have a better defence to it.
The next question I'm briefly trying to, Garvin has asked is I think summary repairs relates to the ultimate condition of the pub when he took it on. So the pub's got damp. Now, does that come into the wind and watertight argument that you mentioned earlier, that damp is something that really should be addressed by the landlord, whatever the situation people find themselves?
Unfortunately, I'm not sure it is quite as clear cut as that. I know I keep giving that sort of an answer.
No, that's absolutely fine. I understand the point.
Yeah. Again, it's probably this fact and degree test. I mean, if it's ravaging damp throughout the building that was obvious at the start of the tenancy and is for some historic reasons, then there probably isn't an obligation on the tenant. The difficulty the tenant has is that there's probably also not an obligation on the landlord. And so if you want to carry on running your business, you're going to have to do some works.
Mark, when we took the red line 7 years ago, we told that all the wiring had been checked and the current test certificate was in place. 7 years on, we're being told we must pay to have all the old wiring removed.
Yeah, that's another tricky one. Tricky one. That I suppose if the certificate that you were given 7 years ago said that this wiring has another 15-year life, you might have a claim against whoever it was that provided you with the certificate. Otherwise, the problem is the ongoing obligation for statutory compliance in most leases, and perhaps situation has changed in the interim.
Typically, pub companies seeking to take a pub back from management are submitting schedules of want to repair when the tenant seeks to renew, rather than a schedule of dilapidation. Is it fair to say that where a tenant has been in occupation for many years with no repair enforcement action, this action by a landlord, an attempt to try and get around the dilapidations process?
Well, you've got to ask the question with that, what is the purpose of it from the landlord's point of view? And it can only have a purpose if they think that the state of the building is inhibiting the tenant's ability to generate profits. So I can envisage in an extreme scenario that the landlord might take issue with, you know, if the building is very derelict and therefore nobody wants to come and visit it, that it is impacting on the rental value, that they might look to do that. Where a landlord actually goes into a property and does the work themselves, that is only during a term of a lease. That they can only do that if there's what's known as a Jervis and Harris clause, which is essentially a clause within the lease that gives the landlord the right, if the tenant hasn't fixed something, having been put on notice to fix it, gives the landlord the right to go in and do the work. But the tenant's defence, in a similar way to a defence to a Section 146 notice, which a landlord might serve seeking to bring a lease to an end for disrepair, a tenant's defence, a valid defence to that would be if the landlord is unable to prove that whatever it is that's in disrepair is causing them any loss. So if it's not interrupting the rental income that the landlord's generating, then it's unlikely that the landlord would succeed. Obviously, where a landlord is legitimately able to go in and do works and presents the bill for the works to the tenant, it's going to be very difficult to argue against.
So is there an argument for the tenant to say that we've been here 10 years and you've never once done any schedule of inspection on the pub, you've never asked us to do anything, and we have then assumed that everything has been absolutely fine? Is there an argument there?
I don't know that the, you know, you haven't told us, therefore it can't be the case argument would run. But the, I mean, this in normal commercial, retail or office property, I don't know of any cases where when it's known that the commercial tenant wants to renew the lease, that the landlord has trundled on and said, well, before I allow you to renew it, and obviously if they've got 54 Act right protection to be granted a lease renewal, it's not going to get them anywhere anyway, but to serve a schedule of dilapidations at that point, because the scenario for the fixing of the rental value is going to be on the assumption that the tenant has complied with their covenants. So it doesn't affect the landlord's the value of the landlord's interest, unless it's an extreme scenario whereby the repairs are so extreme that the investment value of the landlord's property, whilst it might be no effect on the current income, it might affect the yield applied when thinking about it as an investment. That could have an effect, but normally it's very difficult for a landlord to prove any loss where a tenancy is going to continue and the rent is at a full market rent. So,
I mean, that kind of sums up where we are. And there's a few people who've put some other comments, but they're kind of supportive comments that we've made rather than direct questions. Ian from the Forum of British Pubs, who I work with, has just put this point here, which is worth just reiterating from him. So, you know, don't view a landlord as a partner. I think we all know that one. Take good advice before you enter into an agreement. Take photos and record everything when you take on the pub, and keep your own records of dealings with your BDM whenever you meet them. I would just suppose like to sum up really before we kind of close down with a few minutes to go, is that when I looked up on the Landlord and Tenant Act, I was kind of very surprised to see that my interpretation of the law was that there is a statutory cap, and I keep coming back to this. There is a statutory cap which basically says that it doesn't really matter how much disrepair there is in the pub, the cap is the diminution of the capital value of the property. Now, to me, that's very, very simple, but I understand that there is that argument has been tossed around within case law for many years. But I suppose kind of reiterating the question that I asked you at the start, do you believe that that is still the best argument a tenant has against an exorbitant and often very unfair schedule of dilapidations?
Yeah, you've got two lines of defence. The first line of defence is your own building surveyor, putting the landlord back in its box in terms of whether there are genuine breaches and what the cost of rectifying those breaches would be. And then ultimately, yes, your defence is not only statute but common law as well. So the statutory protection is in relation to repair items, thanks to the Landlord and Tenant Act 1927, Section 18. And the common law protection is in relation to anything else where the landlord's loss has to be demonstrated and the cost of the works being claimed has to be reasonable. So yes, absolutely, those protections apply to pub tenants as much as they apply to any other commercial tenants anywhere.
So basically, and the process is that someone, a surveyor, a Regulation 18 surveyor, would survey the pub as if the work had been done and in its current state. And if there was no material decrease in the value of the pub, then effectively it could be argued that actually there was a nil dilapidations claim.
Yeah.
Simple as that.
Yep.
And what we really need, guys and girls, is a decent solicitor to make those arguments, because we are, many of us, faced with dilapidations claims of £60,000-70,000 on a frequent basis. So you know, that was absolutely great. I asked Richard for an hour of his time, and I've got that. I you know, thank you so much. Thank you for all those people who have come into this and contributed in one way, shape or form. If I have missed out your question, please accept my apologies. I will do everything I can, not necessarily to go back to Richard because I don't want to take up any more of his very valuable time, but I will try and get answers to you on these issues. Hopefully this has given everybody some pause for thought as to what the way many tenants are treated with this sort of automatic, you know, there's your delapse bill, you're gonna have to pay it, that's all there is to it. I think we'll all agree from what Richard has said, there are many arguments that can be made which can benefit us all going forward. And what we're going to try and do, myself and Ian, is pull together the support for people so that those arguments can be made and challenged. But I'd just like to say thank you very, very much. Is there anything, you know, Richard, before we kind of sign off, that you'd like to add or kind of?
No, just that. Thank you very much for inviting me, and I very much hope that it won't be too long before I can visit some of your establishments.
Well, that would be great. I think we all feel exactly the same about that one as well. Okay, well, at that point, guys, I'm gonna switch this off. Thank you again for all your help, your contributions, and your support. We will get this recording out once I can find out how to do it. And again, thank you, Richard. Really appreciate it. I will give you a call, formally thank you a little bit more personally, separately. Okay.
Great. Thanks very much. Bye-bye.
Thank you. Bye-bye.